for permits, and then waiting for approval. I'm required to get approval to make changes to the aesthetics of the neighborhood. In this case, the town made a radical change in the appearance of my neighborhood without feeling the need to consult or even consider informing the residents that they're changing the aesthetic or the environment of the neighborhood. I pay very high taxes where I live. Why was I not considered in this decision? I do not live in an industrial area, so I never suspected that the town would allow these DOS towers to be placed on a quiet residential street, let alone 2 towers on one road. What makes it worse is that now we are stuck with this. My neighbors have come and spoken at town meetings like this, written letters, and have done everything your staff has told them to do. And nothing has been done on our behalf. Nothing. It seems the town of Oyster Bay is working to help some people in our town, as Mr. Saladino has promised to do so. 2 residents had their DOS towers removed. 1 was removed, or it was never put up due to a technicality. The other was moved with no explanation. So why can't our towers be moved too? The 2 DOS systems went up without a notification or any information provided, so can't that be enough reason to remove ours as well? If they went up without consideration of location or without your knowledge or without our knowledge, why not take them down? I know the town has been working to have more control over the placement of these antennas in the future. However, what about us? Can we be grandfathered in to show the residents you really care? These DOS systems and poles could be relocated or removed since we had no say in this matter. How can you just leave us behind? Why do others in this town matter and we do not? Because that is what you seem to be saying. Are you saying to us, you don't matter and we will not help you? 2 families have already sold their homes that are in close proximity to these DOS towers. Why do we have to feel forced to move away from our homes? We feel we're being exposed to dangerous radiation 24 hours a day, 7 days a week. Who will buy my home? If given a choice between a house on a street with 2 DOS towers or a street with none, what would you choose? I would choose the street with no towers. The town of Oyster Bay has agreed to allow co-locating, which means they will allow more communication systems to be added to the existing poles, which means the 2 poles on my block can now have more communication systems added to it. This can allow more dangerous effects to our health, more deterioration to the beautiful aesthetics of our neighborhood. There is no testing. Nothing is monitored. Who knows what the level of exposure is to us? Workers need special suits to service the equipment and can only work on the system for short periods of time. I get to live all day, every day, with 2 systems in close proximity to my home. Both the town of Hempstead and the town of North Hempstead will not allow a DOS system to be closer than 150 feet from a residential home. There must be a reason for that. Why do these towns protect their residents like that? What do they know that the town of Oyster Bay does not? This is a huge injustice. We want these DOS systems and poles removed or relocated. Let's be fair. Take care of the residents who vote for you. Make us feel that we matter. Please don't leave us behind.
Thank you, Mrs. Clark. Thank you very much for your time here today. I want to just stress that although you may be feeling that we're not doing anything, the town of Oyster Bay is doing quite a lot. Your feelings and your issues and your community is a very, very high priority to us. I'm going to bring the town attorney up to explain to you what we have been doing and what you can expect us to continue to do. But we are currently the #1 municipality in the nation fighting against these sorts of instruments in our communities. So we'll bring our town attorney up.
One more thing. I know going forward you're protecting, but I'm here today because we are stuck. I mean, once they're up.
But that's not the case. We are negotiating with the company to do just what you're asking. I have one of these towers on my block. I understand how you feel, but we want to correct the record so that you and the entire public understand what we're doing to try to get them removed and how we've adjusted the law. We've held public hearings. We have been praised by residents who have been dealing with this situation in the way we changed the law, and we are on your side 100%. I'd like to bring the town attorney up to explain and inform you and the public.
Is there a timeline that this will happen? Is there,
Our town attorney
it's in the works is what you're saying, that this is going to happen?
Our town attorney will answer all of those questions because of the legalities and the current legal situation. I'm limited to what I can say publicly, but I can tell you that this is a big priority. We've proven that with our legislation that we've already passed, and the fact that we are negotiating with this company to try to remove them from your neighborhood. I'd like to bring the town attorney up, but one thing I want to assure you and every other resident, that we are on this. This is as big a priority to us as it is to you, to your family, and to your neighbors. We all have these in our neighborhoods, and we have heard loud and clear many times how the public feels about them. And that's why we have created the most stringent legislation in the nation on this. And we are the leaders in the nation in fighting this equipment in our residential areas.
Okay.
But I do understand your feelings, I do understand your concerns, and we will continue with this fight in a legal and appropriate way to utilize everything in the law, including all amendments we need to make and change to continue to advocate for the residents. That's important here, that you know and your neighbors know you come first. There is no reason to side with these companies. And again, I have limits on what I can say and the other elected officials can say publicly to you right now. But if you knew what I was thinking, you would feel very relieved. I'm going to ask our town attorney to come up and to explain. You're very welcome.
Thank you, Supervisor. And if I just may note, I add my own personal note of sympathy to this woman, as I know the entire town board does. I have to limit myself to certain facts that I can explain for her benefit and for the benefit of the public. In the first instance, the company that erected these poles with these devices on them, Crown Castle, applied for highway permits and obtained them. But to a large degree, the town of Oyster Bay was kept into the dark as to what was actually going on. In addition to applying for highway permits under our existing code, I'm not referring to the recently enacted legislation for wireless communications, under the existing code, it is our position that they were also required to apply for building permits. They did not. It came to our attention when some of the residents who noticed them coming up on their blocks in front of their houses came before the town board, and immediately the town board said that there are no more permits to be issued, highway permits. And rapidly, the town attorney's office determined that building permits should have been required for the existing poles and for any poles going up in the future. And then very rapidly, we began drafting a statute, hiring an outside firm that was the leading firm in this area representing municipalities against the wireless communications companies to help us revise our code and put into place, and we have now put into place, the most sophisticated Wireless Communications Act to regulate these matters going forward.
Just to interrupt you for a moment for the benefit of the residents, while you use the term sophisticated, I use the term stringent. Is that also a fact?
It is absolutely correct.
And what has our motivation been throughout this entire process?
Protect the residents, the taxpayers, and their concerns from everything, including the aesthetics. For example, as this lady who came and spoke to you now was concerned about the aesthetics on her block and for her house. That is one of the many concerns of the town of Oyster Bay. I have to repeat again, it's as if we were slowly invaded by stealth by these towers ourselves, and our only participation in the erection of these towers was that they had to apply for highway permits, and with the use of the highway permits, the towers were erected, but the company never applied for building permits, and since they're brand new, we ourselves, until they were brought to our attention, didn't even immediately recognize that the company had run afoul of our own building codes as they previously existed. I would add that at our hearing on the Wireless Communications Act, where we revised our code and we added the most stringent requirements for any cell towers that are being erected, we listened to the public, including a number of very informed members of the public who were familiar with the effects of these devices and were familiar with the state-of-the-art issues with respect to these devices. And so we added even more stringent, to use your word, Supervisor, provisions to our code than exist in the other townships and other municipalities. Just by way of example, the testing of radio frequencies has to be done at a greater interval, a more rapid interval in the town of Oyster Bay now than in any other municipality.
Are we ensuring that they're doing this testing?
Yes, we are. The next step, sir, noting that building permits should have been required for the erection of these cell towers, we began to remove, and did in fact remove, 2 of the cell towers. About the same time that we removed 2 of the cell towers, again, as the speaker correctly noted, we removed 2 of them. One was not, it did not fail to get erected. It was erected and we removed it. And then we removed a second one. When Crown Castle, who had sued the town of Oyster Bay, came forward and said, the matter is under litigation. Your claim about the building permits not having been obtained is one that the court will have to decide. If you do not stop removing poles, we will march into court and get an order to show cause. And in getting an order to show cause, we will have the court instruct you that until the litigation is resolved, you are not to take down any more poles. Rather than have a judge instruct us along those lines, we agreed with Crown Castle that pending the litigation, we would not remove any more of their poles. But by the same token, we have not issued any new permits.
Was the motivation to not remove new poles at this juncture in part to help us with an overall strategy to protect our residents?
Absolutely, Your Honor. I'm sure that the public can understand that faced with an order to show cause, stopping us from using what we would call in the law self-help to remove these towers, having a judge order us to do that rather than saying, fine, we won't remove them until the litigation is over. Impliedly saying, you ain't heard the last from us. But we're not going to take them down rather than have a judge order us not to take them down. It is in fact a strategy that we employed. I can't say too much more on that issue regarding litigation strategy.
I'm just going to ask you one other question on that issue. We have had conversations to this effect so that the previous speaker Ms. Clark can feel more assured, as well as our residents, of our intention. Can you speak to our conversations and my directive to you on this issue?
You've directed the town attorney's office, and I believe all departments, to take every step possible to protect the public, to assure that the quality of life and the conditions currently existing in the town remain, and that is our highest priority.
And in terms of moving poles?
Well, with respect to moving poles, again, we agreed not to move anymore until
for the time being. For
the time being, without because if we didn't agree to it, we would have been so ordered by a judge in federal court. We may as yet, but again, I'm only going to make one statement on this subject, negotiate, even during the pendency of the litigation, with our adversary. I know our adversary. I don't want to call them our enemy. They are our adversary. They view themselves as providing an important service to the public and one that the public demands, and they have their own view. We don't share all of their view of what they're doing and what they are. They are our adversary, not our enemy. And we may yet be able to, in fact, we are now striving in every way possible to negotiate with them. That doesn't mean that those negotiations will be successful, but as the lawsuit unfolds, I have a great deal of hope and optimism that the residents will be pleased.
Good, thank you very much. My directive continues. We must continue to do everything within our legal power to protect our residents and to continue to negotiate to have poles removed from this equipment removed from residential areas. And I would state to the public, every municipality, and I've spoken to many on this subject, is of the same feeling and strategy that the public, including we ask Ms. Clark and everyone in the public, to continue to lobby Senator Schumer to change the law, our United States Senator, to change the law to give municipalities the right to direct where these may go and not go, and that ultimately will be the means by which we can solve this problem for our residents, for our town, and for all.
Yes, sir.
Thank you.
Thank you.
Our next speaker is Danny O'Connor.
Thank you again, Danny O'Connor, 9 Sylvia Street, Glen Head. I just want to bring to the town's attention and maybe some of my co-residents within the Glen Head Seacliff area, Glenwood Landing. We have a major problem with New York American Water. I know you've heard it. I feel like residents are coming up to me 5-6 times a day because they're looking to me for help because I've been pretty vocal in the community. But the company is out of control. They are sending out bills. I had an unoccupied house, brand new residence, a 42-day bill. They stated that the house went through 45,000 gallons of water and sent me a bill for $422 for the time frame that not one person was in the house. The house was not under construction. No water was really being used other than a little bit for the grass, which is not going to amount to 45,000 gallons. In reviewing that bill, I called American Water, and I've reached out to some state politicians, and I've met with Lou at one of the community meetings, Mr. Imbrodo, and I challenged American Water, and I asked them to send me some information. I told them the usage seemed incorrect. They had billed on that particular bill. It was a 2-stage bill, and they billed on one particular bill for a 15,000-gallon line item, when it was listed under theirs as 11,200 gallons. And I challenged also the validity of the rates because I've made this public, and we've actually sent some paperwork to the State Attorney General's office, which really hasn't want to get involved and keeps sending us back to the PSC, which really unfortunately does nothing, and they're not really looking out for the residents. As I've heard here, the town wants to look out for the residents. But 2 different rate sheets, meaning pricing. Their office in Merrick sent out one form, and then I picked up another form for the same time frame that was in their Seacliff District office. I've given copies to numerous people, including the state senator. I then told American Water that I believed it was erroneous bills, so what I did is I don't not pay my bills. So I informed them that I'm going to the bank, and I opened up an escrow account, and I deposited the money that they said was due on that bill into an escrow account. Their way of fixing that after I challenged it was they took that amount on that bill and added it to another one of my accounts. And that's how they fixed it, which I think is totally wrong. Legally, how they could even do that, commingling bills, different account numbers, I'm not sure, especially after I informed them that I was not paying the bill. It was just you were not receiving the money, and it would sit in escrow until I got some correction on an erroneous bill. But long story short, they really are a nuisance. They are a problem. We have residents who are checking their bills a year ago, and in a 3-month period, they went through 13,500 gallons of water, and then this year, they converted the bills to monthly, and lo and behold, in that 1 month time frame, that residence per se went through 13,500 gallons of water. So there seems to be quite a number of issues. They're not inspected on their equipment, the calibration. We have firefighters that live and work in the area who have even spoken to how they calibrate the equipment on the vehicles and stuff, and have told that, you know, sometimes when you hit a bump, that calibration goes out. So you could have people installing these meters, dropping them, ruining the calibration and putting them in. But there are numerous elderly residents getting ridiculous bills. This is a major problem that needs attention yesterday, and I don't want to be up here twice sounding like attention needs, to be that fast on everything. But this is a major, major problem that even on the state level seems to be going slower than it should. But it really ticked me off when I'm telling them there's an erroneous bill and they decide just to take that amount and switch accounts and add it onto one of my other accounts. I don't know if legally they could do that, but no one seems to be overseeing this, and they're operating in your town. So I come to you for help on the matter, but it's a real big problem. And if you when you look up their phone number to call their Merrick office, you can see the list of grievances that pop up, because they really don't get maybe even a 1-star rating. And then if people call their Tennessee number, which is their 1-800 number, very rude. And additionally, there was a phone call with one of the Nassau legislators and the governor's office. And unfortunately, the representative from the governor's office did not seem too enthused to even want to have to tackle this problem. So we definitely need some attention to this. And it really is a major problem, because there's no oversight on this company that's sending out bills that are absolutely ridiculous. And I understand there were votes that they're allowed to pass on their taxes, but even the consumption levels are very questionable. So I'm just asking for additional attention in a quick time frame, because it's a major issue in those communities, as I do believe it is in Merrick and some of the other communities in Long Island. Thank you.
Just so I could address your issues, we have been consistently fighting back against this company. We have had contact with the Controller's Office asking for audits, and the PSC, the Public Service Commission, PSC. And while it is not within the power of the town, it's the state that oversees them and the PSC, we have continued to lend our voice. So you know of our great commitment to be in lockstep with you. I, for one, also have New York American Water where I live. So we concur with your feelings and your information you've brought here. We understand that this is a big issue, and we continue to be your voice with the state and the Public Service Commission, who has the legal authority over them.
Thank you. And the real interesting part is those two sheets, two different price structures, and it seems like they just get away with it.
I would suggest after the meeting is over that you sit with our town attorney and give him the specifics. That could be helpful in our fight with that.
I have copies in my truck. Thank you.
Our next speaker is Constance Goodwin. Constance Goodwin is no longer here today. If she comes back, we'll certainly entertain her comments. Kevin McKenna is our next speaker.
Afternoon. Yeah, it's the afternoon. Good afternoon again. Kevin McKenna, Syosset, New York. Just real quick on the cell phone tower matter, after listening to Mr. Nichella. I remember reading in the lawsuit that the town, prior to them going out into the neighborhoods and putting these repeater towers and poles, someone from the town actually went out and physically surveyed the locations that they planned on putting this equipment. So I respectfully disagree with the statement that you made that all of a sudden one day these things started popping up. You know, and also it wasn't a surprise that they started popping up, because once the first one popped up, I'm sure someone from the neighborhood called up and made the town aware that they're popping up, and basically there was nothing that could be done because you gave them the permits to do it. And I just want to remind
It's
you all
not exactly
that,
the
let me
case,
just finish,
sir.
I just want to remind you
Certainly.
all
Certainly.
that when this first came up, I was able personally to get Verizon, after numerous phone calls over the course of a few weeks. I finally got the executive department of Verizon on the telephone, and the executive department of Verizon told me that that these contractors for Verizon should not be putting these units in residential neighborhoods. And shame on the town for giving the authorization to do so. You wanted to say something?
I'll wait till you're done with your
Okay.
statement.
I just want to also, I don't know how to say this, but when I first started coming to these meetings, and before you were appointed, when you were appointed, I truly was hoping that everything that you said you were going to do, transparency, ethics, you know, all the promises that were made. And aside from that, as you know, I do a lot of work, and I've brought a lot of matters to everyone's attention, and some of them you've actually implemented. It was me, and I'm going to pat myself on the back, and you'll probably tell me that it wasn't, but it was me because I foiled everybody who had town vehicles. And when I finally posted it all on Facebook and it caused such an uproar, everybody was shocked at how many vehicles were out there. I brought it to your attention, and you implemented that, and it's saving the town a lot of money. The reason I bring this up is because I bring many matters to your attention, and I feel like I am, you should be thankful that residents bring these types of things to your attention, because that's how progress and change occurs. And what brought me to say this today is that when I attended the meeting the other day in Plainview for the Historical Society that you, Mr. Saladino, went and spoke to 20 or 30 historical interested people there, I raised my hand to ask a question, and you immediately get on the defense with me when I was just going to ask you a fair question. And you made a point of telling the historical ladies that, before you interrupted me, and you made a point of telling them that Mr. McKenna attends town meetings. What does that mean? Because I attend town meetings, I'm not allowed to ask a question? I'm not always, just so you know, I'm not always looking to be difficult. And there's actually times that I want to give you the opportunity to elaborate on something that might be helpful to you, and you shut me down. And I would just appreciate that going forward you understand that I'm not always, I'm looking to help you all with information. And I can go on with other things that you have implemented that I've brought to your attention, yet I feel like I'm treated like you wish I didn't come here, and it shouldn't be that way. And I just want to close with the fact that yesterday in the Newsday, you obviously made headlines over the sign matter. And, you know, I've done some research, and it's illegal to put signs on the public right-of-way. And you are here to enforce the town code. And the town code is that signs are not supposed to be on the public right of way. Yet, before the Sons of Italy feast in Massapequa a couple weeks ago, signs are lined up by not just you, but by others, all along Broadway, and that's illegal. So I was driving in Plainview the other day, and Mr. Imbrode, I just want you to know I have one of your signs in the trunk of my car, which you know, I hope you don't get mad, but I'll pick up anybody's signs that are on the public right of way, and I have yours in the trunk that was placed, and I'm sure you didn't do it personally, but you guys all need to come to some sort of a truce on the sign thing.
Mr. McKenna, I just want to say, these are political matters. They're not appropriate for a governmental meeting.
So it's only fair that, you know, there's a five... What's that?
The right of way is a government matter.
He's talking about a political campaign. That's a political matter. Okay, thank you.
I'll tell you what, Mr. McKenna.
In closing, you all, you have 5 candidates, and you should all be able to do the same thing equally. And I was very, very dismayed that 2 commissioners from the town, Commissioner Tooman and Mr. Ryan, they're out taking, it's reported, they're out taking down physically. Are they being paid to do this? Taking down signs in Seacliff? Are they being paid to do that? That's a question. And what's unclear in the Newsday article is that Brian Nevin, who we pay $163,000 and $169,000 with benefits, who's nowhere to be found. I don't know where he is. He's in the back room now, but he avoided that what you allegedly did has nothing to do with the town of Oyster Bay, he says in the newspaper. You're the supervisor of the town of Oyster Bay. How can a man make that statement to Newsday? And who, he said he's not, who is your campaign person if it's not Brian Nevin? Who is it? We'd like to know.
Again, this is totally inappropriate.
Thank you very much,
town
Mr.
meeting.
Thank you for your opinions. I do want to point out that the statements made by the previous speaker are not accurate. And this issue continues to be pushed forward by those with a political agenda. And this is a place not for politics, but for government.
You're the only one who thinks it's a political agenda.
Mr. McKenna, I'm going to address this because you brought up this issue of how you feel as though you're left out and how you're not being listened to. But you asked to speak at every single meeting, and we afford you that opportunity at every single meeting, and we listen to you. At the same time, people have from time to time brought to my attention your writings on social media, and it's a very different approach than you have here today. And it paints you as someone very different than the way you've presented yourself at today's meeting. Our next speaker will be Bob Fryer.
I have invited anybody from the town board to contribute to my social media and respond to any inaccuracies, and no one has been able to respond to any inaccuracies.
Good afternoon, Mr. Fryer.
Good afternoon. Robert Fryer, 33 Chestnut Lane in Woodbury. First thing, I have a couple things that I'd like to ask is, I'd like you to address today's newspaper article where you were personally witnessed taking down signs that our campaign paid for, you personally, as well as, besides Commissioner Tooman and Dave Ryan. Do you have anything to say about your behavior and their behavior? They work for you, and you're the CEO of the town, and you're doing the same illegal things that they're doing. So do you have any comment about that?
Let me ask you 2 questions. First question is, you've stated that these signs were your property.
I just asked you a question, so please answer the question.
We're either going to listen to your statement as part of public comment, or we're going to get this issue resolved. Were these signs your property?
These signs were paid for by our
campaign.
Okay, so you're stating that these were your property and the property of your
So
campaign.
these signs were paid for by our campaign, and they were put up legally.
And were these put up by your advocates of your campaign?
Sure.
Okay. The statements that have been made on this issue are not accurate.
So are you denying that you did what is stated in the newspaper?
I'm not going to go back and forth with you.
It's a simple yes or no question.
Here in a government venue, I have answered the question, and I'm not going to go back and forth. You may make the statement in your public comment period to whatever is reasonable.
There's been a police matter now referred, action complaint filed against you this morning, okay, that for your actions, and you won't even answer the question of whether you did what witnesses have said you did, and you won't even condemn the town employees that there's absolute proof of what they did? That's shameful. Okay, I'll go on to the next.
Mr. Fryer, we all know that you are a political candidate.
There you go. It's a political
in
thing,
a political season.
Okay. All right, next question. As you know, a lawsuit was brought against the town. I believe you're a defendant in the lawsuit about mailers like this that have come out. This one showing, I guess, I don't know if it's supposed to make people think it's your family, but also certainly nothing that should go out, going out at the taxpayer's dime. This, I believe, was probably at least $40,000 or more that we paid for by the taxpayer. This document certainly was more than $40,000. So I would like to bring up, I'm sure you know personally, Councilwoman Erin King Sweeney from the town of Hempstead, and you know her father. She recently announced that she is proposing a comprehensive ban on all town of Hempstead mailing and promotional brochures for a 45-day period prior to any election whatsoever. And it mirrors a federal law known as franking statutes, which applied to both houses of the U.S. Congress.
You know, Mr. Fryer, I'd like to bring that forward to the town.
Yeah, so
Students starting.
I would be willing to work on that with you, Councilman.
So my question is, and thank you for answering, because you were answering my question before I asked, is how does the entire board feel about this? And not just the supervisor, but these mailers. And I would ask you to stop effective immediately, and let's have a special meeting right now and vote to stop this effective immediately, because it's blatant electioneering, it's blatant campaigning, and that's why residents brought a lawsuit against it. The town is in dire financial needs, and you're spending our money to promote yourself. This particular document, I think, mentions Joe Saladino 17 or 18 times. It's unbelievable. I've never seen anything like this before. So, I'll leave it to the rest of the board, but I'd love you to discuss this, and I think this is something that needs to be brought forward by this town board. Thank you.
Thank you, Mr. Fryer. It's important to point out that Mr. Fryer is a political candidate currently running for office, and that on all of these political mailings, we are asking to collect email addresses to more efficiently communicate with the public via email. And we use this opportunity to encourage the public to give us the email addresses as is part of the information, so that as we move toward communicating with the public through email, which is obviously a very efficient process. From day one, we promised transparency. Part of the process of providing transparency is to communicate what we are doing with the public and getting their feedback. We have gotten many positive comments and positive feedback and positive suggestions on our road to turn around the town of Oyster Bay, facilitated through these mailings, and we will continue to do that. Our next speaker is Sandra
There was one more
Decker.
thing I wanted to bring up, that Since
We have
Mr.
rules that
Nocella
have to be
brought it up
followed.
before, just to follow up on the investigations, and you mentioned that there were no criminal investigations for town, that the town was paying for. My question is, are there any ongoing criminal investigations that employees are having to pay for out of their own pockets, whether they be as witnesses or targets? Because you mentioned that earlier. And then my other follow-up question is, in what investigations are ongoing, and what law enforcement entities? Is it U.S. Attorney, SEC? Could you just
We'll bring
expound
our
on
town attorney up. Mr. Nocella.
I'd love the board to comment on the...
Thank you. Yes, thank you. Mr. Nocella.
Supervisor, we generally, just as we don't reveal the identity of the witnesses, we generally don't reveal specifically any agency that's involved. I just want to note that...
As is the case with every municipality in the country.
That's correct. And I want to note that it is our obligation to provide for the legal representation of someone who was a witness through no fault of their own, but as a result of their employment by the town of Oyster Bay. And that could be an administrative proceeding, a civil proceeding, it could involve a mixture of that plus a criminal investigation, so on and so forth. Well, not getting into the actual agency, the fact is that these people are merely witnesses. If they were not witnesses, then they would not be entitled to have representation paid for by the town of Oyster Bay. As for ongoing investigations, whether there are or are not ongoing investigations is not something that we're necessarily privy to, other than the fact that witnesses have been identified, been told, you are not a wrongdoer, we don't believe you are the subject or the target of an investigation, but we need to take information from you. And that is the sum and substance of what we do when we provide counsel.
Mr. Nocella, on another subject, the issue of mailings has come up. I know that these mailings have gone through the ethics process before any decision was made. Can you please speak to this?
Yes, they are informational in nature. No political party in any of the mailings has ever been identified. No person has ever been identified in the mailings as a candidate for any political office. The mailings do not endorse any political party. They do not endorse any candidate for political office, nor do they criticize or condemn any person who might have been identified as a candidate for public office. They don't urge political activity of any kind, either to vote for someone or to vote against someone, or to vote for a proposition or against a proposition. They don't solicit political campaign contributions on behalf of any particular candidate or a political party. They don't even mention any upcoming political elections. They perform a service which the town provides of disseminating information to the public, and that's it.
Excuse me, Mr. Nocella. Is there any reason, is it possible that we could enact a measure like the one that was proposed in Hempstead to prohibit mailings for, let's say, 30 days prior to an election?
It is entirely possible. That will be up to you to decide whether or not you want to do that and whether it will come before the board for a vote. I see no legal impediment to enacting such legislation. I just caution the board, and I caution in strong terms. Right now, we have been sued. I believe the suit to be frivolous. I believe the suit to be politically motivated. The very thing which the suit is attacking rather unfairly, claiming that the mailings are politically motivated. I believe the suit to be politically motivated, a fact that has not come out to the public, which is that the putative taxpayer plaintiffs are all contributors to the Democrat slate of candidates for a supervisor and town board, that the law firm, including the lead lawyer for these people who are suing under this lawsuit, was an unsuccessful Democrat candidate for political office, that the law firm itself has made donations to at least one of the candidates for political office, and it was clearly a political attack. Ironically, the thing that they're attacking, there is no basis in the law, in the view of this attorney representing the town, there isn't a basis for attacking it. But because that lawsuit is pending, even though in my judgment it will be dismissed, and I believe it to be frivolous, I caution you not to comment at this time, because anything you say could potentially prejudice in that lawsuit until it is finally dismissed.
And Mr. Nocella, in addition
Just
to
to
these
repeat,
acts...
Councilwoman, the simple answer to Councilwoman Alessi's question, there's nothing to stop us from enacting such a provision at some point in the future. I just think it's ill-considered at this time when we're being sued.
Mr. Nocella, in light of the facts you just presented to us, can you confirm that as these parties bring lawsuits against the town for, in your opinion, political reasons, it just increases costs to the taxpayers?
Oh, it absolutely does.
Very sad.
The loss of time just from my own staff in responding to this itself is a substantial cost, not to mention things like service. If we ever get into the deposition or discovery phase, additional expenses are attendant upon the lawsuit.
So you've listed many of the criteria as per the law, which would confirm that these mailings are not political, and you have informed the public that the lawsuits brought, as you have stated, for political reasons are costing more and more money to our taxpayers. And we have also communicated to the public that these mailings have multiple purposes, including asking for emails. And so that we can, that we have, in fact, collected up and continue to collect emails to get away from mailings with the motivation to continue to communicate with the public. And finally, that communicating with the public is part and parcel to creating a much higher level of transparency. Reclaim New York, a very independent organization who, quite frankly, sued the town in the past, has rated us the #1 most transparent municipality. And it's also important to point out, while our opponents try to make political points by bringing up issues like this, these are the same type of mailings that their colleagues are sending out in North Hempstead and Huntington and other municipalities which are controlled by people of their party.
That's correct. And if they are doing so and they're not making political references, merely providing information to the public, including information that would restore confidence to the public in their government, they're providing a valuable
Mr. Town
service.
Attorney, I understand what you're saying, and I'm being very careful with my words because I don't want to prejudice our position. And I'm not your political opponent, Supervisor Venditto. I'm not running, and I'm not...
Not at all.
But I can tell you that just because something is ethical doesn't necessarily mean that it's money well spent. And that's my issue.
Well, the point you bring this up.
The Supervisor makes a good point about emails. My question is, do those emails get shared with a political party or a candidate, or are they held in lock as a part of town record that will not be shared and used to, in the future, to use on either side, to use to promote a political candidate?
My understanding is they're used for government purposes only.
And they're not going to be,
No, in fact, if someone were...
fished out?
No, because, Councilman, if someone were to attempt to do that, they'd fail. People subscribing to the email service who want to hear from the town via email, whether, you see this sometimes even with credit card companies or banks. They'll tell you if you'd like to save a tree or eliminate paper, save a stamp, you can do this through the internet. If you then were to... many people who are political opponents, for example, of each other, might be subscribing to these email services. Good luck to anybody who wants to parse out the ones who they think will favor them politically and not favor them politically. It's just almost impossible to do. They're used for governmental purposes, not political purposes.
Thank you.
And to be quite honest with you, I'd rather see a paper one for one reason. This way we can see what's going on. Because anything done by email, we have no way to track it, if you would. No way to make sure that everything would be on the up and up.
Thank you, Mr. Nassau. We really appreciate it. As you know, this is why they call this the silly season. Having said that, it's important for the public to know that I have imposed a 30-day moratorium on all mailings in the town of Oyster Bay to make sure that we are in lockstep with all of the issues and that we are in lockstep with our residents. The last mailing, now printing, will be out by week's end, and that will be the last one until after November 7th.
Who approves the mailings? Does the town board approve the mailings?
Mailings are vetted through our ethics process, and every mailing that has gone out has been found to be 100% ethical.
The ethics board sees it?
Our next speaker is Sandra Decker of Syosset.
The ethics board doesn't see it.
Please stop calling out from the audience.
Hello, Ms. Decker. Good afternoon.
Good afternoon. So I'm Sandra Decker. I live at 169 Cold Spring Road in Syosset. And I'm bringing up the DOS systems again to support what my neighbor said earlier this afternoon. I have to say, Supervisor Saladino, I've been at this podium before. We've met before, and I am truly, truly disappointed in your response. Months ago, I was told I am in lockstep with you, the residents. I promise to do everything within my power to get these towers down. I don't think that has happened.
Were you here for our hearing on the legislation change?
Legislation, yes. And going forward, I'm happy for those residents, although I feel like with this new co-locating now, you know, I don't really approve of that either, because those of us who do have the towers up in front of our homes are now going to get bombarded because other companies can come in and they can put receivers on the existing pole that already has a receiver.
Ms. Decker, did you hear our town attorney saying that we are negotiating and utilizing our stepped-up stringent code to negotiate with these companies to remove the towers?
I've been told that since April.
But you did hear that.
Okay, so are you promising me that mine is coming down? I live
I am
150 feet away from Berry Hill Elementary School.
Okay.
Every single day, not only is my family and the houses around me, 1,500 feet, which includes Berry Hill Elementary School, are being exposed to RF radiation. And I don't care what kind of information is brought out against it. We know there's just as much to support that RF exposure over time kills. I'm not willing to take that risk with my family, and I'm sure those other Berry Hill families don't want their children exposed to this every single day. I have been fighting for months, and I have gotten nowhere.
Well, that's not the case. You haven't gotten nowhere because now we have the most stringent code.
I've been told they're not coming down. I have been told by the
I don't know
county,
who said
because I
that.
live on a county road, I have been told they are not coming down.
Okay.
I have been told by Bill Nimmo, I have been told by Supervisor Ann DeMichaels, I am sorry, Crown Castle is digging in their heels, we understand, but these towers will not be removed.
That's not the case. They cannot assure you of that because we are currently negotiating with the company to remove them. You mentioned and you informed us, as we're aware, that you live on a county road. Have you contacted Nassau County?
I have contacted everyone. I have been to board hearings, and because of what
Board,
I have
town
said...
board, town board
No,
hearings.
no, county hearings, and because of what I have said, the county has enacted all of this legislation, which is wonderful now, making it... it's a more strict process for the telecommunication companies to put up their equipment. They have to pay $800 now to put up the equipment, which is really a drop in the bucket. I mean, we know they make billions of dollars a month. So, okay, it's great. They're going to have to go through a more stringent process now to get these up, but we still know that in the end, they'll win and they will put this equipment.
Well, this brings me back to the point I made before. I have been asking the public to help us to lobby Senator Schumer to change the federal law that would give us the right to remove them.
I have been
What
writing
response have you
no
gotten
response
from
whatsoever.
Okay.
None. No
I can't
response
control
whatsoever.
the senator and his office, but you are getting a
You
response
can't
here.
control this town, what happens
And
in this
that's
town,
why-
right? You are the supervisor?
Absolutely. That's
Okay.
why here we've instituted the law that gives us more teeth to get them removed. And I'm assuring you that we want them removed from residential areas. I'm also assuring you that we have limits by what we can say because of the federal law, and we have to follow the advice of our counsel to not hurt our position in helping you.
That litigation has nothing to do with the DOS system in front of my home.
The DOS system in front of your home
because I'm on a
is
county road.
under the control of the county. You're coming here.
Yes, because
To
you have to
listen.
work together. It is within the town of Oyster Bay, correct? So the county said,
Is not within the control of the town of Oyster Bay, and I'm not shrugging you off, and I'm not pushing off responsibility, but the law is the law, and we do want every single one removed from a residential area. And we did prove that by changing our law so it is the most stringent in the nation. And I will tell you, and our town attorney will too, I understand your frustration. I get it. We're not even allowed to talk about health issues at all. Some people will take that we don't care, but we are not allowed by law, by federal law, to talk about those health issues.
actually, that's not true. But, okay.
After you speak, I'm going to ask the town attorney to come up. I don't know why you would say that.
That's fine, that's fine. The
I don't
other
know why
question.
you would be, in essence, asking me to hurt our position in court.
I'm not asking you to hurt your position, because I really do want what's best for all the residents of this town.
You too, and we all do.
Yes, okay. My other question is, two of them were taken down. One, there was an issue with the location of the pole, and the other one, Ms. Denise Stefanos came down. How did that pole come down?
All right, we'll bring our town attorney up, and we'll answer your questions now.
Okay. Thank you.
Very simply, Supervisor, we had identified the failure of Crown Castle to obtain building permits as a good faith basis to take down all the towers. I can't explain in what order we began, but we began to take down towers. We took down one, we took down another, and then we were threatened with an order to show cause. I almost feel as if I had counseled the town, and our outside counsel had counseled the town differently than we did, then perhaps the residents would be more sympathetic to our position as a governmental unit. Perhaps if a federal judge had ordered us under contempt of court to stop removing poles, the public would believe that we are at the moment handicapped, where our hands are tied, I should say, from removing any more poles. But they did threaten to go into, Crown Castle did threaten to go into court and obtain a order to show cause during the pendency of the lawsuit. And order to show cause to prevent us from taking down poles would have been a standard litigation tactic. We maintain these poles were erected without proper building permits, and that is going to be, that remains our position, and that is a basis, we believe, not only for us to have begun taking down the poles, we had hoped to take down all of them, because none of them had building permits, and then require all poles, if any, ever in the future, to comply with the, as you noted, most stringent regulatory scheme of any municipalities after we had enacted it. But we were stopped. And there's nothing...
Stopped by who? Let's make it very clear to Ms. Decker and to the public.
The pendency of the lawsuit, had we continued taking down these poles while the lawsuit was pending, we would have been slapped with a restraining order by the judge, perhaps paid financial penalties at the expense of the taxpayers.
So Ms. Decker
and prejudice,
understands.
just to finish the point. No, I appreciate why you want to get to the next question, Supervisor, but I think she needs to know, and the public needs to know, we would be slapped with financial penalties for having taken them down during the pendency of the lawsuit, and then we would have prejudiced our claims in the lawsuit, because the judge would have viewed it as usurping her position as the trier in this case. There may be a jury, the case may be resolved, the judge will be handling dispositive motions, but if we came in after a lawsuit began and they brought an order to show cause saying you cannot, during the pendency of this lawsuit, continue to take down poles, and we were ordered by the judge, then everyone would know our hands were tied. And the reason why we didn't wait to be ordered was so that we didn't prejudice our position in the lawsuit, where we hope to achieve ultimately that very result.
So to repeat this in layman's terms, because I made this statement earlier, By continuing to do this, which would have made Ms. Decker and others happy, we would have hurt our long-term strategy to get these poles, get this equipment out of residential neighborhoods. Is that correct?
Absolutely. In fact, the poles might have been restored to their place if we left it up to the court and we didn't refrain. Again, it seems like the only way to have the public completely understand this is if we had let it play itself out. But that would have been a tragedy. It would have been a tragedy for everybody.
Mr. Nacella, if we are in fact successful in court, then perhaps Ms. Decker might get some relief with the county as they could rely on the rulings.
Well, it's entirely
No, it's hypothetical, but we have to get through this first before, perhaps other municipalities can try and find similar relief.
Well, your point, Councilwoman, is a good one. It would be, and I believe Ms. Decker's point that you're addressing is a fair one too. We have a situation where a pole in a county right-of-way was erected within the town of Oyster Bay. We don't control that. We didn't issue the permit. Our building scheme doesn't apply. But nonetheless, success in our lawsuit and negotiation in our lawsuit is likely to encompass other jurisdictions as well. Yes.
Okay. Before you step down, just so Ms. Decker is clearly upset at poles being there, and the poles have been there, and other residents are too. But what she hasn't communicated is the fact that the town has continued to take many steps under my administration to change this situation and to bring relief for our residents. Can you just go over some of the many steps that we have been taking within the bounds of the law, and can you speak to the issues of the federal law that tie our hands, and quite frankly, tie the county's hands where her street is located, where her home is located, and where the equipment she came to speak to the town before is under the jurisdiction of the county, even though we continue to lead this fight? What can we continue to inform the public of so they can fully understand that they shouldn't be disappointed in the town, and quite frankly, we're taking the leadership position in everything we can do under legislation that, by her own words, Senator Schumer seems to refuse to change. And that legislation being changed on the federal level would give us more rights. And if we had those rights, we would go in and remove those poles immediately, all of them.
Yes, we certainly would if we did have those rights. But the federal government has preempted the locality's authority within this area. They've made it clear that they want the poles coming up within certain parameters. They have entirely taken out of discussion for municipalities the subject of health concerns. The federal government has already determined, with whatever reasoning applied, with whatever information was in front of them, that the health concerns shall not be a concern of localities when they regulate the placement of these poles. So that is not something that we can use either as one of the reasons why we remove a pole or one of our strategies in the lawsuit that we have currently pending. I really don't like talking about strategies in that lawsuit. I'm afraid I may have said already too much. But nonetheless, it's the federal government that has enabled these companies and limited the localities and tied our hands. What we've done was, again, once it became clear to us that these poles were being erected with these mechanical devices on top, and I don't believe even crediting the assertions in Crown Castle's lawsuit that any town employee who might have gone out and looked at the locations that were being contemplated or may have been involved in any way in issuing highway permits had the slightest idea as to what was going to be erected in any given place, or the speed with which they were going to be erected, or the implications of what was going to be erected for the residents of the town of Oyster Bay. If they had, I believe the town would have acted immediately, as you did, as the board did, when it did come to our attention. And then the next thing that happened is when it came to our attention, the board and the supervisor immediately said that there are to be no more permits issued. We halted all permits. When you then directed that the town attorney's office explore this issue more thoroughly, we realized that our currently existing code required Crown Castle to have building permits as well as highway permits. And again, that was the basis on which we removed and began to remove poles and intended to remove all the ones that had been erected. In the meantime, Crown Castle sued with the benefit of the federal legislation in place. They sued us in federal court. And as it's appropriate for them to have made this threat. I don't mean it was a threat in an inappropriate way, but it's very simple. If you're going to take down another pole, you're going to face the judge, and you're going to face consequences for it. It's our property, we erected it. It's your position, Town of Oyster Bay, that a building permit is required. We're going to dispute that with you, and if you take that away from the judge and take matters into your own hands and take down the poles, you're going to pay the piper, and you'll probably lose your lawsuit. It wasn't stated that way, but that was their position, and that is why we had to agree in front of the judge, in front of the court, that we would not engage in more self-help and remove the poles as much as we wanted to.
And so Ms. Decker can get some relief, because we can totally understand why you would be frustrated with this situation. Have we had discussions in terms of our long-term strategy to stop this process and to have all the poles that we have control over removed?
Yes, we've had extensive discussions along
And
the way.
by doing that, are we assisting Nassau County, where, quite frankly, her comments are best placed, because that's the right-of-way there is owned and controlled by Nassau County, not the Town of Oyster Bay, but do we in fact assist through our process Nassau County in getting Ms. Decker relief?
Yes, we are assisting Nassau County. We are working with them. I can't speak to the particulars of what happened with Nassau County's responses to her complaints, and I don't know what obstacles Nassau County faces with respect to removing poles in their right-of-way. But we are cooperating with them, we are working with them, and I believe we've been the leader in helping our residents in this area.
That too. Obviously, Ms. Decker's next logical question would be, when will my pole be removed? And we realize that there's a legal process in place. But can we give her some information about how that process will unfold?
I really can't comment any further. I'm afraid I may have said too much already.
Well, we can tell her that we're continuing to fight this in court.
Yes.
And we're continuing to negotiate with the company to have these poles removed.
Right.
And we're continuing to use all legal means afforded us to advocate for our residents and to have these poles moved.
That's correct. And the real problem, as you pointed out, Supervisor, is the federal government has enabled these companies, not the Town of Oyster Bay. I would pose this question rhetorically to anybody who thinks the Town of Oyster Bay has done something inappropriate or permitted these things. What more would you like us to do? Give me the suggestion. I'd love to see if I can't do it.
And we'll be happy to do it. Ms. Decker, what other questions do you have?
I understand that I live on a county road. I've gone to the county, and they did say that you needed to work together. Okay, that's why I'm here.
Okay.
It is within my free speech right and everyone's free speech right to discuss health issues concerning this, and that's why I said before that's not true. We all have First Amendment rights, so we can bring up the health issue.
We in the town can't discuss that. We in the town cannot make statements about the health based on the federal law. I didn't say you can't.
Right.
But it wouldn't be fair or appropriate, quite frankly, to say that we don't care about health risks.
No, I never thought that.
Okay.
I never thought that anyone was insensitive or didn't care. I just felt that the response wasn't there that should have been there, perhaps. Like I said, I am disappointed. And I did. And I understood this beforehand. I just felt like I had to come here again to say, hey, nothing is working. I think we need to try harder going forward. I understand what's happening here, but I think these telecommunication companies, in the end, quite honestly, are going to have their way anyway. It's going to be very difficult to stop this. And I think we're going to have to work together as a community, as a town, to try to prevent even more from going up. One other question. So
I'm sorry to stop you, but just so you feel more assured of where we are on that, we have a moratorium on this. No new poles, no new equipment can be installed.
Right. And that's, again, temporary, so we have to,
But that is a step that we're empowered to
in
do.
the right direction, yes.
That's one of the things we can legally do, and we're doing everything that we are legally able to do.
Yes.
And we've hired outside counsel, who is the nation's expert in this, to
Okay.
once again prove our commitment
Yes, I
to
knew that.
fighting this for you.
Yes, okay. So co-locating now happening, and the other thing, and correct me if I'm wrong, but my understanding is that there will be monitoring of these systems now? Is that true?
There is.
That has been put in place already?
Yes.
Okay, and by whom? Who will be monitoring these
Let's hear it from
DOS
the experts.
systems?
Let's bring our town attorney or attorneys up so we can verify exactly the
And
way.
clarify what monitoring is, please.
Yes,
Thank you.
certainly.
There's regular testing and monitoring of the emission of radio frequencies, the operation of the equipment. It's my understanding that it's to be paid for by Crown Castle, by the cell tower company, but the people who actually perform it, I don't remember the name of the company, but the name of the individual, I want to say his name is David Comey. I may be mistaken. Comey is definitely his last name. He's working on our behalf, and yet we don't have to pay for his costs.
So that we are ensuring that they're doing this monitoring and making sure that it meets all standards.
That's correct.
So do they work for Crown Castle? The people who are doing the
No.
monitoring are part of?
No, they're only paid by them.
No, but,
I
but,
understand they're being paid by them.
but under the statutory scheme, Crown Castle has to pay for the monitoring. So
They
they
do
pay
not
for the
work for
monitoring.
them and answer to them, they answer to us.
Okay, and
Right.
how often,
And quite frankly, the federal government.
because we know that they're monitored in the beginning when they're put into place, and there's a certain RF emission that is reported, and it's all well under federal regulations, and then we know that what the companies do is they amp up the power over time because no one's regulating them. So, how often will this company or entity go out?
I can't give you an exact answer on that question, but I will look into it and get you an answer. Because I simply don't know with what frequency, and it would be my view that, and I believe this is the case, but I don't want to say that it's the case without checking, that to some extent it's done randomly to test for the very thing that you're talking about.
Ms. Decker, do you have any other questions? Because we want to entertain all of your questions and get them all answered.
No, I was just concerned about the monitoring, because if it's not done regularly, like I said, they can remotely increase the power and the power, the EF that comes out.
Yes, no,
So that question has been answered, that they are regularly monitored.
Right, but how often is that?
Okay, we'll get that information, and let's make sure we get that information to
Certainly.
Ms. Decker. One last question. As we've stated over and over again, has been stated on the county level and our council and all of the attorneys who know this exceptionally well, that we must continue to lobby the federal government to make these changes. You stated that you contacted our United States Senator's office. What happened when you called them?
There's been no response. There's been
So they'll take your name, they'll take your information, they don't get back to you? They,
no, they don't even respond. Just
please have some respect for the residents.
you get the thank you for your email. We will be in touch.
And you hear nothing. All right. Well, we have to, as a society and as residents and community people, we have to continue to keep the pressure on our federal senators from our state, so because they're the ones empowered, and we must demand that they enable local municipalities to have a right over that. The law was written specifically, in my opinion and the opinion of council, to stop us from having any rights as to this issue of where they go, what the removal of them. If we can be given that right, these polls will be out the next day.
Just one other thing. The town has said they didn't issue any permits, so I guess after this litigation is over, they can go back and say, hey, you didn't get a permit from us, so this has to come down. The county has told me that they didn't issue a permit for the equipment that went up on my pole, so I'm assuming it's going to be the same.
I can't speak to the county, and I will tell you that our team is cutting edge, and we have brought in the best firm in the nation on this to show our commitment and that we truly care about getting these removed and truly care. And we will be successful. It's going to take some time, but we will be successful. We've already created the most stringent legislation anywhere in the country. So to believe that nothing is going to happen or they're going to come right back, I don't believe that to be the case, and we're certainly putting our resources where our heart is on this.
Okay, so just to clarify, they would only need a permit, or they would need a permit on a county road, they would need a permit from the county, and
Let's
from
bring-
the town, they would need a permit as well?
Let's bring our commissioner up so you can hear it directly from the commissioner. Would you please come forward, Commissioner Macarone?
Assuming it would be twofold going forward on county roads, it would be permission from the town and permission from the county to pick up equipment.
Right, it would be similar to the structures going in the town right-of-way. They would first go to the highway department to get the road opening permit, and then they would come to the building department for a building permit. That would be the same situation with the county. They would first go to the county for the location and road opening permit for where they're going on in the county, and then they would come to us.
Do we have authority over the county right-of-way? We could require them to get a permit for the county right-of-way?
Yes, a building permit.
But it wasn't like that when money.
No,
That's why
no.
we changed the
No,
law.
that's why it's been
That's why,
changed
as
with
soon
the
as
law.
I found out about these, remember, I came in the 1st of February, so as soon as we found out about these, which I believe was early March, we immediately set the process in place to push back, to change the law. You had to do it legally. There were public hearings. I believe you were here at the...
I didn't know that anything was happening. I came home this.
We advertised this, we put this on the town website. Many other people who attend meetings on a regular basis were here, and so they found out about it in all those ways. I reached out and I met with civic associations. We were in the media, making sure the public knew that we were doing this. And I'd have to look to see if we sent out a mailing on this, although there'd be some people in the room who wouldn't want you to get information via mailing and have made that point.
I thought you meant that residents were notified that the system was going to go up.
When I came here, when I became the supervisor of the town, as soon as we found out about the issue, we immediately took all these steps. Some of them were already in place. We put up the moratorium, we removed some of them, we changed the legislation through the legal process of holding the hearing, which you knew about, because I believe you were here that day. So the system is working in terms of notifying the public, listening to the public. We made changes to embrace some of the additional ideas. Dr. Berg was one of the people who presented some very powerful and insightful aspects that we put into the legislation. Okay, and we are going to continue to fight this, and I'm hopeful you'll continue to be in contact with us, because you're absolutely right. We need to work on this together, and we will work on this together. And David will beat Goliath in the long run.
Thank you.
Thank you very, very much. Our next speaker is Mr. Versacchi.
Thank you,
Good
members.
afternoon, Mr. Versacchi.
Good afternoon, Mr. Saladino. Thank you, members of the board. I just wanted to follow up. I know there was some discussion earlier about the American water issue that impacts the region in the northwest part of the town involving Seacliff, Glenhead, and Glenwood Landing. I think Arthur's left, but where are you? Oh, there you are. Hello. So I wanted to thank the attorney's office, the town attorney's office, for reaching out to me after the last meeting. We are sharing the litigation. Since we last met, there's been 2 Article 78s filed, one by the village of Seacliff itself, and then also one by a not-for-profit group with individual plaintiffs challenging the PSC order. My intention is I'm working as a pro bono counsel with our civic groups to hopefully coordinate response from the town, and any continued support you can give our civic groups, we really appreciate. Those Article 78s were filed against the PSC order itself, and we're hoping the town may be able to give us some a friend of the court brief. So again, I just wanted to thank you for that, and also advise the board that there are 2 pending lawsuits that have been filed against the PSC. We think that's the most immediate relief we can get at this time for ratepayers. Just so you know, and I'm not sure if the town has any ability to help on this because it is a private water company, the issues on billings are a huge problem with reconciling basically what I would consider a weights and measures issue. The calibration of these meters are off. We have 70-year-old women who have meters that are reading, hundreds of dollars of water bills a month. So there's something doesn't smell right in Denmark. So we're gathering data, and we'll continue to share that with the town, and thank you for that.
Just so I can add to that, the residents can request that their equipment is tested or replaced.
They have been, and because it's a private water company, and they're getting a lot of that, there's a lot of difficulty and pushback. So we're going to need every friend we get in government to help
And you can
push
count
this.
on us to assist the residents on this
really
issue.
appreciate that.
We
Thank
already have been in terms of contacting the Public Service Commission, asking the Controller's Office to audit them.
Yeah.
We understand this issue, and we hear the public loud and clear. While this is, the state has the right, as you know,
Yes.
the state has the right to oversee and push back, in fact, on them, and we are continuing to lobby the state to do so.
Right, and quite frankly, if you have the opportunity to speak with the governor is the head of the PSC, and any pressure you could bring to bear when you speak to the governor, that would be very helpful for our
Please
cause.
count on that, not only this year, but in the years to come.
Thank you. Pardon me, I'm sorry I wasn't able to be here for the full budget discussion, and if you address this, I'm sorry. I'd like to know when and how the public will be made, copies of the proposed budget will be made available to the public?
Certainly. Just so you know, the budget hearing was not today.
Right, it was just
That's
the
coming
proposed
up.
budget.
And-
The 17th, I believe, is the budget hearing?
Yes. And what date will the proposed budget be available for the public? Do we have our Finance Department? Okay, we'll get you that information.
Will that be put online for the residents to download?
Absolutely.
Okay, that would
Absolutely.
be great. And finally, I just wanted to address, and I wasn't aware of this, but in 2013, the town was sued by a former employee, a gentleman by the name of Chris Briggs, and there was a settlement in that lawsuit because it involved town employees removing political signs. And as you mentioned earlier, this is silly season, Mr. Saladino. So unfortunately, on Sunday morning in my own neighborhood, as I was walking down the street, I witnessed 3 gentlemen removing political signs from that were properly placed in the village of Seacliff. And, I personally went up and asked them what they were doing and discussed this. This happened 9:30 on Sunday morning. Eventually, what I was able to uncover through people in the community who knew these gentlemen, that one is actually a commissioner of the town of Oyster Bay, a gentleman named Mr. Eric Tuman, who I believe is the commissioner of the Office of General Services, as well as a gentleman, Mr. David Ryan, who my understanding is some sort of supervisor in the highway department. I believe this conduct is a direct breach of the Chris Briggs lawsuit, and I wanted to draw this to your attention. I will draft a letter, I believe, to the Ethics Board, would also be appropriate, but I will copy the members of the board on this. As this does involve a prior federal settlement, I would hope that these town employees, and in fact all town employees, are reminded of their obligations under that lawsuit. The stipulation of settlement does specifically require that town employees receive a notice, a written notice, about the town's commitment to make sure that the games of the past end. And I'm hopeful that that notice has been sent, and if it hasn't, that it be sent immediately. And again, I don't expect that there'll be any resolution of this today, but I will be filing a formal complaint about that as a citizen. And I hope you will address that seriously.
I will.
I raised this as a citizen, and I personally witnessed this. And as you may or may not know, you can criticize a lot of people, but I'm an officer of the court. I'm a former prosecutor.
And an attorney.
I am an attorney, and I also have took photographs of this when I confronted them. And quite frankly, I was shocked.
Who did you witness doing this?
I personally saw Mr. David Ryan, Eric Tuman, and a third unidentified individual. My understanding is the vehicle they were driving, and when I walked up to them and they got into it, and I took a photograph for the car with their license plate as Mr. Ryan's driving it, they literally were getting on.
Did you recognize that third individual?
I don't have a photograph of him, and I'm sure.
But you didn't recognize that?
No, I didn't know him. I, of course, know Mr. Tuman.
So it's no one that is in this room?
Not right now.
None of the 3 of them or anyone in this room?
Well, Mr. Tuman's not here today. I have seen him at other board meetings. I've seen him in photographs with you at, like, for example, announcing the redesignation of the South Town Hall office for permitting. He's standing very close to you in there.
But what I'm asking you specifically is none of the people you witnessed are in this room?
Not today, no.
Okay.
I've seen Mr. Tuman here in the past, though. I just want to be clear about that.
Okay.
So, look, it's because the town has enough prior problems, we don't need new ones. And I'd really like to avoid this becoming a bigger problem. So I appreciate you addressing it, and I hope you'll take it seriously.
We absolutely will address it. Thank you, Mr.
Thank you, Mr.
Psaki.
Sally.
And all sides should take this seriously. A man, one of your supporters came up and confessed to stealing my signs. So,
No, I don't, no.
everyone
He
should
actually
take it.
did
Excuse me.
today. He
No,
confessed and he said it's in his
excuse me,
trunk.
Excuse me.
Steal it, it was garbage on the road.
He is not a supporter of mine, so I'd appreciate you not making accusations politically on the stand, Mr. Umbrodo. That is
Just
not...
asking for mutual respect like you're asking from us.
I'll be glad to talk to you outside about that. This is town board official business. I'm talking about a federal lawsuit that was violated and a settlement for the court. If you want to discuss politics, I'll gladly do that outside. It's not appropriate here.
It's not appropriate here, that's true.
Thank you.
And as an attorney, Mr. Psaki mentioned that he is an attorney. I assume that you know that under Nassau County law, the placement of signs of any kind on utility poles is illegal, and those who place signs on utility poles are breaking the law.
Fabulous. The point is that there's a federal lawsuit that says town employees...
There may be.
But let me just... The town employees are not supposed to be violating a federal order that...
No town employees that I know of are violating any code.
Okay, so I already understand now that you're not going to take my complaint seriously.
I didn't say
I will
that.
submit. I just told you that two employees...
I actually told you that I am going to take it
So let me just
seriously.
clarify. Two employees were witnessed personally doing this, okay? Town employees, including senior members of your administration. So they were witnessed doing it. And it doesn't matter how you think they were placed now. You have none of the facts about how they were placed or where they were placed.
Well,
So I'm advising you that situation...
What I've read in the newspaper, and there were statements made in the paper that just are not accurate, but the reality is that we're two responsible adults here.
That's correct.
And we must be in agreement that the county law specifically states that the placement of any kinds of signs on utility poles is illegal in Nassau County, and that action is an unlawful act.
Is it the responsibility of town employees to remove them from county poles or village poles?
I don't know of any town employees as part of their employment removing poles. I have not heard of
Removing signs from poles.
removing signs from poles. I have not heard of town employees. Having said that, and over the course of many years, on election morning, for instance, I've seen county and state employees going up and down the roads as part of their employment in a state vehicle. I've seen this year after year on election morning, removing signs from poles as per the law.
Correct.
So we're in agreement that it is legal for the removal of these signs, and we're in agreement that it is against the law, county law, and I ask you as an attorney
We're not in
to check
agreement
it.
on your statement. So,
Okay.
listen, I don't want to go back and forth with Mr.
We can
Saladino.
provide that information to the media and to anyone else.
I don't care about the media. I don't know who's here from the media, but here's the point. The point is that there is a federal settlement with this town where town employees...
I encourage you to provide us with that information. We will happily look at it, and as I promised, we will take this very seriously. But there is no doubt in my mind and in the mind of our attorneys, and quite frankly, all attorneys who have checked the law, that it is illegal for anyone to place any kind of signs on utility
Mr. Saladino,
poles
you are
in Nassau
trying to
County.
switch this. Now, this is just where it gets ridiculous to me, personally as a citizen. That is irrelevant to the point at hand. The fact is that two senior people in this administration were seen tearing signs down. That's the issue. It doesn't matter any of this other stuff that you're raising. It violates potentially a federal settlement with this
I would
town.
suggest
Mr.
you read the
Supervisor,
law
I
before you
have
make
allowed
that
you to speak.
statement.
You owe me the respect as a citizen to let me finish my statement.
Go ahead.
Okay? That is what the violation is. I'm addressing this because I wasn't aware there was even a prior settlement of this. It doesn't matter anything else other than that town employees were removing signs. Okay? That's the issue that you need to be focused on. And that's what my complaint is about. And I thank you for your time, and I hope at least if you won't listen to me, that the members of the
I've
board
already
understand.
told you that we're
Again,
taking
Mr.
this
Saladino,
very
please allow me to
seriously.
finish my statements. You do not show any respect. So the point here is that if you won't listen to me, I ask the members of the board to understand that there are lawyers on this board, and I know you all take your issues, your responsibilities seriously. There's a violation of potentially of the Chris Briggs settlement. and I ask you to look into this when I send the letter in. I'll address it to all of you, and whatever it is, but I thank you for your time today.
Thank you, Mr. Vasecki.
My answer to this candidate is that we do take this very seriously, and that we will read this, and we will look at it, and we will continue to take this very, very seriously.
Saladino, you are disrespectful in a way.
I just told you we're taking it seriously,
You just called me a candidate.
sir.
I am standing up here as a citizen of this
Then we
community.
take what you brought to us very seriously.
Thank you. Don't make comments as I
And
walk away from the podium.
Sir, I make
You
comments.
called me a candidate. What is wrong with you that
Is
you
that
would do that to
incorrect?
me?
Is
It
that
is
this-
incorrect as I stand here today. I come to these meetings for a long time, and I provide information about my community. And for you to make a little snarky comment as I walk down the
Snarky,
field,
Ed.
calling me a candidate is disrespectful, sir. I never do that to you. You sit up there, you're entitled to be called the supervisor because you are right now. I will always give you that respect.
I appreciate
Don't disrespect
that.
me as I
Not
walk
all
away
of
from
you-
the podium.
Not all of your colleagues do.
That doesn't
But
matter.
I
It's me standing here, sir, and I
ask you-
respect you, and you should respect me as I walk away. I'm a member of my community.
Respect
I give
you
my time
now,
to the
and I
community. I
respect you
coach
as
the
you
kids.
walk
I do
away.
everything else that a good citizen does. Don't disrespect me.
I won't disrespect you, and I have assured you, although your response and your anger speaks that you didn't hear what I said. What I said was that I respect what you're doing. I respect the information you're going to provide us. We will look at this. We will address this, and I ask you in turn to check on the county law, and that's a reasonable statement to make to you, and it's reasonable for you to check on the county law, and I know when you do look up the county law, you will see whether or not you feel it's relevant. You will see that it is illegal to post signs on utility poles in Nassau County. And being that this is the campaign season, while I don't fully believe this is the venue for this, you've brought it up, and the reality is it is relevant to inform everyone in the public, candidate, resident, not candidate, campaign worker, not campaign worker, that it is illegal to post signs on utility poles, whether they're in Seacliff, Farmingdale, Hicksville, no matter where it is in the town. And we have to be in agreement that following the law is something that's relevant to this discussion. And we have to be in agreement that I've told you multiple times that we will respect the information you bring to us, and we will look at it, and we will address it.
Thank you.
And that concludes our town board meeting. Thank you all for attending.